Welcome to This is Getting Old, moving towards an age-friendly world. I'm your host, Melissa Batchelor, and today we're continuing our financial caregiving series with Cameron Huddleston. And today we're going to be talking about legal authorization. So welcome, Cameron. Um,
Hi.
and maybe before we get started, you can just briefly tell us about yourself.
Sure. I am the author of Mom and Dad, We Need to Talk: How to Have Essential Conversations with Your Parents About Their Finances. I was inspired to write this book because of my experience with both my mom, who had Alzheimer's disease, and I was her caregiver for more than 12 years, and my father, who died without a will at the age of 61 while in a second marriage. And so he did not have those legal authorizations in place, even though he knew better. And so I want, my story is a cautionary tale for people to have these conversations with parents to find out what sort of legal documents they have and don't have, and what sort of planning they've done, and get some details about their finances so that as they age and if they need help from you, you have the information you need to help them.
Right, and that's another subject is to talk about, second marriages and all of that stuff. Maybe we'll have time to talk about that a little bit. Um, so let's talk. Well, we can just jump right into it then. So, what are some of the different legal documents and authorizations that someone needs to have? I think most people are familiar with, medical financial power of attorney, which we can talk about what each of those do, and then a living will, kind of your code, like do not resuscitate paperwork, that type of thing. So, just maybe start at the top, and we'll just go through each of them and what they all do.
Okay. I want to start actually first by saying that, when people hear the term estate planning or end of life planning, legal documents, people often think, well, this is something that rich people do. I don't need to worry about an estate plan because I don't have an estate. Well, if you want to have a say in who gets what when you die, who makes financial decisions for you if you can't, who makes medical decisions for you if you can't, then there are essential legal documents that you need. A will is going to spell out who gets what when you die. It lets you name an executor, someone who's going to handle your estate. And estate is really just a fancy word of saying your property, your belongings, your assets, who's going to handle that when you die. Um, if you die without a will, state law is going to determine who gets your assets. And that means your things might go to someone you don't want to receive those things. Or it also might mean that your property doesn't get divided up in the way you wanted it to be divided up. Like maybe you were in a second marriage and you had stepchildren, and you didn't have children from your first marriage, but those stepchildren are not your biological children. Well, there's a good chance they won't get anything because of the way state laws work. And so unless you have something in writing, a will or a trust, you're leaving it up to state law and a judge to determine who gets your things. That's why you need a will or a trust to spell out who gets your things. You need a financial power of attorney document that lets you name someone or more than one person to make financial and legal decisions for you. If you can't, it's best to have what is called a general durable power of attorney. General meaning you're giving that person broad powers. If you limit it, then let's say something happens to you later in life. You have a stroke, you develop dementia, and someone has to step in and manage your finances for you. If you have given them limited powers, they're going to have a hard time managing your finances for you. Durable means that it remains in effect if you do become incompetent. You also need a healthcare power of attorney. This is also called a healthcare proxy. It's someone who can make medical decisions for you if you can't. And a living will or an advance directive spells out what sort of end of life medical treatment you do or do not want. Do you want to be on a feeding tube? Do you want artificial respiration? It's important to put this in writing so your family members don't have to make these decisions for you and they don't end up fighting in court over whether to keep you on life support. And really it's really about control. I know a lot of people when it comes especially to power of attorney, they think, well, I don't want to give up control of my finances to someone. Well, you're not really. What you're doing is you're choosing someone you trust who can step into the role of financial manager for you if something happens to you. And the way you can maintain that control is just to simply hang on to the document, because the person you name as your power of attorney, they can't just go to your bank and say, hey, Joe named me his power of attorney. I need access to his bank account now. It doesn't work that way. The bank is going to need to see that document. um, a lot of times banks might even ask the account holder to sign documents that they have, or you might have to sign an additional document, stating that you are indeed the power of attorney. You might have to get it notarized. But, you know, if you can't trust someone to be your power of attorney, don't name that person as your power of attorney, but just hang on to the document and tell them when and how they can access it. And that's another important part of the equation. Once you have these documents, you've got to let people know you have them. Let your kids know, your other family members know, the person you named as your power of attorney, the person you named as the executor of your estate. You've got to let that person know where those documents are and how they can access them. If they are stuck in a lockbox at the bank and no one has the key, then they can't get them. And it's not going to do you or them any good.
Right. And so, and even with a living will, that's really a very generic document that, I actually advise people to, you need the living will, which is kind of your first level, kind of tier one advanced care planning, your advanced directive. But there are other documents out there called the five wishes, which really, because there's no way to tell like what specific situations your loved ones are going to find themselves in making a decision. So you want to have had enough conversations about, what you want to have happen at the end of your life, that they can kind of make decisions based on principle. And so I think that that's also something to keep in mind. Now, you also mentioned a spring power of attorney in a prior episode, and I don't think I'd ever heard of that before. So,
Yes.
what is that?
So there are different types of power of attorney. As I mentioned, you can have general or limited. Limited might be, you might, for example, let's say you're going out of the country and you need someone to sign some real estate papers for you. So you can designate someone as your limited power of attorney who can only sign documents related to real estate for you. General, you give them broad powers. Springing means that that power of attorney will spring into effect when certain conditions are met. Typically, and you can spell that out in the document, typically people will say this will spring into effect if I am deemed mentally incompetent, through a diagnosis of whatever, dementia or whatever, stroke, whatever. You just spell it out what those conditions are, and typically, you can say I need, one or two doctor's diagnosis. And so that is certainly an option, but most estate planning attorneys and elder law attorneys will discourage people from getting that springing power of attorney because it makes it much difficult for that person you named as your agent to step in and help you. Like, let's say you did have a stroke and you are in the hospital now and you are no longer able to manage your finances on your own, and your child needs to access your bank account to pay those hospital bills. Your child needs to get on the phone with the insurance company to discuss your insurance claims, and there is a springing power of attorney, but now your child is going to have to go and get those doctors to go to stand in front of a judge and say, yes, this person is no longer competent. I mean, this could take a while. And in the meantime, the bills aren't getting paid. Collection notices are being sent. Your kid is maybe like, dipping into his own bank account to pay your bills until he can get access to your bank account as power of attorney. And so it does make um, it does create a lot of hurdles that your agent's going to have to jump over in order to start acting as power of attorney.
Right. And then you'd mentioned kind of where to put these documents. And, I know in my own experience, whenever I've updated my paperwork, they've, the attorneys kept a copy. I've been given a copy, and then I've been given a copy to give to the executor of my estate. So, but you had mentioned keeping your
Right.
copy. So, where are some other places that you need to make sure that these documents are and that people can access them? Because I know from my perspective, it is something that would definitely need to be added to your medical record, at least the healthcare
Yes.
power of attorney, not necessarily
Yes.
the rest of it, but the healthcare power of attorney and your living will definitely need to be given to your primary care provider, and or your hospital, I guess.
Exactly. Yes. So those medical documents, like you said, that healthcare power of attorney, the living will, advance directive, if you have, do not resuscitate documents, you want your doctor to have copies of those documents in your file at the medical office, or whatever. They're going to scan it. They're going to, put it in your patient portal online so that they know if you are in the hospital and you don't want to be resuscitated. There is that documentation there that they can refer to and say, this patient doesn't want to be resuscitated. This patient doesn't want to be on life support. This patient has named their child as their healthcare proxy. Yes, and giving your executor of your estate a copy of the will is a good idea. The power of attorney is the one document that you might want to hang on to if it is that general durable power of attorney. Ideally, you name someone you trust wholeheartedly, and you can go ahead and give them a copy of that document, because when they do need to step in, they've got to show an original to the bank. Financial institutions will accept copies, but typically they want it to be a notarized copy. So you're going to make a copy and you're going to go to a notary and they're going to sign off on it, or you could take the original to the bank. They're going to make a copy of it, keep it in the files. But even if you trust your power of attorney 100%, you're still feeling a little anxious about handing over that power, hang on to the document yourself and put it someplace safe, in a home safe, in a filing cabinet that can be locked, and let that person you've named to be your power of attorney know how they can access that document, so that if something does happen to you, they can get it, they can step in and start helping you with financial matters.
Okay. So I will also put in a word of caution here to family caregivers, because this actually happened to a friend of mine. She, her dad lived in Virginia. She lived in North Carolina, and she needed to hire someone to come into the home to help him. And just, the financial paperwork was not on her radar whatsoever. But so she hired a certified nursing assistant, but she didn't do, which she assumed that a criminal background check had been done on this person. And within like 30 days, this woman had convinced this elderly gentleman that they needed to get married. She'd found all of his notarized financial documents and was in the process of, had gotten him to a lawyer and was in the process of having his paperwork changed to make her the power of attorney. She had run up like $25,000-$30,000 worth of credit card debt. And so if you're caring for an aging parent and you're putting outside caregivers in that home with that person, you need to be aware that you need to remove all financial paperwork so that, frauds, elder abuse, elder fraud scams, don't happen.
Right.
Because all this went down, and she went to the police and they're like, well, sorry, like she had access to the paperwork. There was actually no recourse um, for her. And I think that the laws in this country just haven't caught up to that level of things that are happening. But they were like, yeah, there was no way to recoup the money. The credit card company didn't help her. So it was, it's like you could press criminal charges, but it was a nightmare. So I was like, well, that's just a note to myself to always be sure to remove all
Yes.
of this paperwork from a home when you have a parent that, if you're assuming if you're having to take over, even if they're managing some of their bills, to be aware of that and to be paying attention. So the other part of the this kind of the power of attorney paperwork you had mentioned, in your experience with your mom having to get different authorizations for things like Medicare, Social Security. So what are some of the other places to think about where you might have to show this to get authorization?
Right. So when it comes to government agencies, a power of attorney is not enough. They have several of them have their own paperwork that has to be filled out. So Medicare, for example, if you are caring for an aging parent and you are having to help manage their Medicare benefits, then in order to get on the phone and talk to someone within the Medicare agency, then you're going to have to be designated as your parent's Medicare representative. It's easy enough, honestly, to go online and get the form, and if you have already been named power of attorney, then you can fill out that form and sign it as your parent's power of attorney. I had to do this with my mother. If you are having to manage a parent's Social Security benefits, then you need to be designated as your parent's Social Security representative payee. This would be best to go to your local Social Security Administration office and sit down with someone there and go through the process of filling out the paperwork, showing that power of attorney document. And there are other responsibilities that come with that. So you have to file an annual report with the Social Security Administration detailing how you manage your parents' benefits, how you spent those benefits for your parent. If you
That
have to
used to
file,
be true for children too, because my youngest son, his dad passed away when he was 6. And so that was my introduction to the Social Security Administration, and always had to do that report. And then 2 years ago, they took that reporting away. So I
interesting.
was like, yeah, I was like, okay. And I don't really know why, except that if I didn't have the manpower to follow up on what people were submitting.
If you have to file and sign a tax return for a parent,
Right.
IRS has its own form that you have to fill out to be designated as your parent's agent. You need to read the instructions carefully, and you will also submit that power of attorney document when you send in the tax return and the additional IRS form. And so um, I would also add to that, for anyone who is, has not yet named a power of attorney, when you go through the process of having that document drafted, it really is best to meet with an attorney. You can find free and low cost wills online. You can find free advanced directives, healthcare power of attorney documents, but that power of attorney document, you really want to get it right because this is giving someone permission to manage your finances for you. So you want to make sure you're giving them the right permissions. You want to have an attorney, sit down and discuss with you what powers you want to give that person. And you want to make sure it complies with your state law. And then once you have the document, it is a good idea to go ahead and let your financial institutions know that you've named a power of attorney. They might have some additional paperwork that they want you to fill out. So if you can fill it out while you're still mentally competent, then they're going to have it in their records that you've named, whatever, Joe Smith. And so then if a few years down the road and they're starting to notice maybe that you're making some mistakes with your accounts and someone else shows up and says, "Hey, Joe, you know, Sally named me power of attorney," but they're like, "Well, we have Joe Smith on record as power of attorney." That will hopefully send up a red flag that something is going on, that there might be exploitation here, like in the example that you cited. But it's also a good idea too to name a trusted contact with your financial institutions. Some will ask for it, some won't. You go ahead and say, "Hey, can I name a trusted contact?" This is someone your financial institution can reach out to if it can't reach you, or if it suspects that there is financial exploitation going on, and they can call up and say, "Hey, I'm concerned about our customer. They named you their trusted contact. Are they having health issues? Is there any sort of cognitive decline? Is there anything we should know about? Because we think that they're being exploited. It's just another way to protect yourself financially.
All right. So that's a lot to think about and to take in. I would recommend that people get a copy of your book, Mom and Dad, We Need to Talk by Cameron Huddleston. So that concludes this episode of our financial caregiving series on legal authorizations. In case you missed it, the first one we did was around how to talk to your aging parents, kind of the why, when, and how. The second episode had to do with older adults or aging parents talking to their adult children and what those children need to know. And our final series will be out next week, and we're going to be talking about top conversations to have, primarily around different types of scams, financial exploitation, abuse, neglect, and fraud. So thank you so much for being with us today, Cameron.
Sure, thank you.
Thank you for tuning in to This is Getting Old, Moving Towards an Age-Friendly World. I'm your host, Melissa Batchelor, and if you'd like to learn more, you can check out my other episodes on my YouTube channel by subscribing and ringing the bell to get immediate notifications when new content comes out. In addition, you can also find the audio version of the podcast on Amazon Music, Spotify, iTunes, and Stitcher. Please feel free to leave an honest review, because more reviews mean more awareness of the podcast and helps us move towards an age-friendly world. If you have a comment or a question, you can visit my website, melissabphd.com. Go to the Contact Melissa tab, and you can leave me a voice message. You never know, it might just include your question or your comment in an upcoming episode.